Hi, this is Lisa DeMonte with MyLegal.com. It's Tuesday, December 14th, 2010, and we're here in Washington, D.C., speaking with Deborah Epstein Henry, author of the book Law and Reorder. Debbie, welcome back.
Thank you so much.
Debbie, we were talking in the first segment about the reasons and the impetus for writing the book. Let's now shift gears and talk a little bit about some of the themes for the book.
Sure. And as I mentioned previously, the book is really broken out into parts 1 and 2. Part 1 is focused on advice and reporting of trends of the industry for legal employers, and part 2 is written for lawyers and law students. So in terms of themes, part 1, the key theme is really what I call making the exception the rule. And what I mean by that is there are multiple career paths in the law, and there are also multiple models of legal practice. And those varying career paths and varying models in the law firm structure, for example, have really never been celebrated. They've been viewed as sort of ancillary sideshows. And what the book really tries to do is celebrate the innovations and educate about the innovations in the profession in all different areas so that legal employers can be more effective in managing their businesses. And so it's making the exception the rule, meaning making all of these alternative solutions to career path models and legal practice models the rule, and gain education and awareness in those areas. The second half of the book focused on lawyers and law students. The themes there are related, and the first is really being your own entrepreneur. The profession has resisted the fact that it's increasingly a business, and for lawyers to be successful today, they really can't wait and sit along and wait for the senior partner to take their hand and show them the way. Instead, they need to manage their own careers and their paths to success by being their own entrepreneurs, meaning that they need to show creativity, initiative, and really be flexible with the ups and downs of practice. And related to that, it's no longer enough as a lawyer to just be a talented practitioner. That's a threshold matter. What lawyers today need to do to be successful, and this is really a theme that I focus on in the second half of the book, is to develop all those other intangibles to success that differentiate those lawyers who wither and those who thrive. So for example, lawyers should be focused on developing mentoring relationships and developing leadership skills and learning how to network effectively and develop business effectively and learn how to manage work-life issues and time management issues and issues of transition and be effective leaders. So those are all those intangible skills that most of us don't learn in law school, but those are really those factors that differentiate those talented lawyers who really succeed and take things to the next level.
So sort of learning the soft skills as well as the business skills?
Absolutely. So being a talented lawyer, there's nothing that can replace that skill and talent and the hard work that comes with it. But on top of that, it's being effective as a business person and being effective at all those soft skills, as you call them.
And can you give us a little bit of insight as to how they can develop those soft skills?
Sure. I mean, there's effective training along these lines all the time. But an example is in networking, that junior lawyers think, oh, well, I'll never have access to the power brokers. I'm not going to even bother to network, or there's no expectation that I'll bring in business anytime reasonably soon, so I'm just going to put that aside. But that's no excuse, because you can't miraculously develop those skills if you become elected an equity partner. So as a junior lawyer, get involved in your bar association. Be a leader and take the opportunity to be involved with the Young Lawyers Division or be head of a Women in Profession Committee. There are all of these different committees, both substantive and other areas at the bar associations, for example, that provide leadership roles, they provide networking opportunities, they provide visibility, you have opportunities to be a public speaker. Those are the types of opportunities that junior lawyers need to really seize from the outset and not wait until years later when all of their colleagues have been working at these angles and they find themselves behind.
Debbie, throughout the book you report on industry trends and you talk about the changes that are sweeping the industry. So who do you think are the drivers of that change?
Sure, and there are a lot of drivers for change, but I see the biggest driver for change, the client. The client is really has gained an increasing awareness that law does not need to be practiced the way in which it's been practiced, And these clients have increasingly gained a lot more pressure from their business leaders who say, we need predictability in your legal department budget. We need to know what the expectations are for the coming year. It's no longer acceptable for general counsels to not have a predictable budget. So clients have gotten pressure from their business leaders, and as a result, they've put pressure on the law firms that represent them to say, we need to have law firm leaders run their firms differently. So that may be pressure to move away from the billable hour model and push towards alternative fee arrangements, which better align a client and law firm interest because there's a sharing of risk. It also is the result of legal department leaders saying, wait a minute, we don't like the way our matters are being staffed. We don't need top-notch attorneys to be handling all of our legal work. Some of our legal work, in fact, can be billed at a much lower rate that can be standardized, and there's no need to do that. In addition to clients, there are many other drivers for change. The most recent one, of course, was the economic downturn, and the past 2 years have really put pressure on the model because the model really has been based on the law firm model has generated revenue basically in two ways. One is to increase hours and the other is to increase rates. And in the past 2 years, neither have been possible. So as a result, there's a lot of pressure on the model from the economic downturn. But beyond that, there are a lot of other pressure points for change. One is the increased globalization and competition for work, that the marketplace has changed and the players in the marketplace, it's much more dynamic and much more competitive. Technology has increased efficiencies and prevented firms and legal employers from charging for services that they previously charged for, or if they're charging for them, they have to charge at a much lower rate. There's the commoditization of the work and the disaggregation of work, meaning that it's being parsed out more and it's being commoditized, meaning it's being done at a much more kind of routine rate. And once again, the fees that can be charged as a result are less. So those are some of the bigger drivers for change across the industry.
Debbie, do you think that the billable hour is no longer a sustainable business model for the law firm?
I really encourage law firm clients to move away from the billable hour model, and the firms that are most progressive on this front are generating up to 40% of their revenue from alternative fee arrangements, and those are the large firms. There are also smaller alternative model law firms that are being developed solely on an alternative model, and so those are small firms that are not charging by the billable hour at all. I really think the alternative fee model is a better one because it, once again, brings that alignment between the law firm and the client, and you want the law firm and the client to be on the same page. You want that sharing of risk. I'm not in favor of discounts of the billable hour, which a lot of people misconstrue as alternative fee arrangements. Discounts of the billable hour are more like flat fees and discounts on hourly rates or capped fees. In those situations, there's no alignment of interest between the client and law firm, and there's no incentive for the law firm to be on the same side as the client. In contrast, a traditional real alternative fee arrangement, let's say like a flat fee coupled with a success fee, then the law firm is getting paid a flat fee, and if they reach a successful result, they receive a bonus. I really am in favor of those kinds of arrangements because it's putting the incentive for the law firm in the right place.
And having them become really a stakeholder or almost like a business partner in the case or in the litigation that they're handling.
Exactly. And if you think about billable hours, they inherently don't make sense because if you look at other industries, professionals are being evaluated based on the quality of their work, their efficiency, and their productivity. In contrast, in the legal profession, lawyers are being evaluated based on hours logged. So if we can move the measure of value into quality of work, efficiency, and productivity as opposed to time spent, I think we'll all be much better off as an industry.
But isn't it a paradigm shift in the way lawyers traditionally think about how they bill and their revenue and their profitability? And with some of these progressive firms, are they in fact seeing that they can use alternate fee arrangements and be profitable and successful?
I think you touch on a really important issue, which is a real tension and challenge for the profession right now, which is reevaluating how to measure value. So we've had the billable hour model in place since the 1950s, and the reason why it hasn't been replaced is because it's been largely profitable. It's only in the last 2 years when law firms haven't been able to raise their rates or raise their hours in the same way that really the model has indicated its weakness. So as we look towards alternative fees and other replacements of the billable hour model, what has to happen along with that is a new way to measure value. And we have to be able to develop metrics to evaluate the quality of a lawyer's work along with that lawyer's efficiency and productivity to be able to measure value and contribution other than through time. But it's an important step the industry has to take, and if we adopt this new alternative fee arrangement, and really if it takes hold, there also will be a question about whether the profits per equity partner measure of the law firm will also continue to be in place, because that model no longer really will fit with the new alternative fee arrangements.
Very interesting indeed. We'll be curious to find out exactly how many of the firms are beginning to shift in the manner of billing. Deborah, let's move towards some of the historic focus on that you have been involved in the past. And historically, your focus has been on work-life balance and women's issues. Is this book broader than that? And if so, how do you incorporate these issues into a larger framework?
Sure, and yes, my historic focus, or how I got involved in consulting, really was in the work-life arena and then in areas focused on the retention and promotion of women. The book is much larger than that, and as I shared with you earlier, the evolution of the issues that faced women and work-life issues really became much broader. So in the work-life context, for example, it used to really be just women with kids who were voicing the work-life concerns. But really, those who are pushing the work-life agenda are much broader. So Gen Y is looking for work-life balance for reasons in addition to parenting, and both men and women who are representatives of Gen Y are saying we want to work differently. But it's not just Gen Y, it's also the baby boomers who are now 70% of law firm partners, and they're looking to phase into retirement differently, many of whom want to work flexible, reduced hours for a period of years before they phase into retirement. So the fact that the demographic pushing the work-life agenda has really expanded shows that these issues are much more relevant, not just to women, but to all lawyers. But also the issues that I focused on relating to women, really the issues of leadership and business development and networking and mentoring, those issues really pervade all lawyers in the profession. And what I noticed in researching this book and through the evolution of my consulting practice is that it's not just about individual constituents who want change. It's really about looking much broader at the structural model of how law is practiced and saying, wait, we need to change the structure here. We don't need to just focus on one constituent or another, but the model is broken. And so the book really addresses much broader themes of the trends in the industry and really how to change the model so that it's more conducive to enabling the profession to perform at a higher level.
Debbie, that's a great segue into our next segment where we're going to be talking about some of the trends that you've identified through your research in the book. So we look forward to seeing you in the next session.
Thank you.